All right, this is Chapter 3, Legal Concepts of Insurance. So in this chapter, we'll explore the legal elements that make insurance contracts unique. A valid contract requires 4 elements, often remembered as CLOC: competent parties, legal purpose, offer and acceptance, and consideration. So insurance contracts have special characteristics. They are aleatory, meaning the exchange of value can be unequal. They are contracts of adhesion drafted by the insurer with little room for negotiation. They are unilateral because the only insurer makes a binding promise, and they are conditional since benefits are paid only if certain conditions are met. Agents act on behalf of insurers under 3 types of authority. Express authority, which is written in their contracts; implied authority, which allows them to carry out routine tasks; and apparent authority, which is based on how their role appears to the public. Several doctrines guide how insurance contracts are interpreted. Indemnity ensures the insured is restored to their original financial position, not profiting from loss. Utmost good faith requires both parties to share all material facts. The doctrine of reasonable expectations holds that policies will be interpreted as a reasonable person would expect. We also must understand misrepresentation, concealment, and fraud. Misrepresentation is an incorrect statement. Concealment is the failure to disclose important information, and fraud involves intentional deceit. Um, Policies may be modified by writers, endorsements, or waivers. Some contracts may be void, never valid in the first place, or voidable, where one party has the option to cancel under certain circumstances. Finally, the other 2 concepts are important. Subrogation, which gives insurers the right to recover losses from third parties; and insurable interest, which ensures the policyholder has a legitimate financial stake in the insured's life or property. Um, so, in this chapter, we'll look at the general law of contracts and the unique features that make insurance contracts different. We'll explore concepts like aleatory contracts, contracts of adhesion, unilateral, personal, and conditional contracts. We'll also cover indemnity, valued contracts, insurable interests, and other key legal ideas that affect how policies are issued and enforced. The material is divided into 5 sections: the general law of contracts, special features of insurance contracts, negotiating and issuing policies, the law of agency, and other related concepts. We'll finish by reviewing losses that can be covered under errors and omissions policy. By the end of this chapter, you should be able to explain basic insurance terminology, identify who the parties to a contract are, and describe the essential elements of a binding agreement. You'll be able to distinguish warranties from representations, understand concealment and recession, compare void and voidable contracts, and recognize the 3 types of agent authority. You'll be able to tell the difference between agents, brokers, and solicitors, and explain why errors and omissions protection is important for insurance professionals. So, insurance contracts are legally binding contracts between two parties, the policy owner and the insurer. In most cases, the policy owner is also the insured, but sometimes a third party can own a life insurance policy. The insurer makes a promise to pay benefits if certain events outlined in the policy occur. But for that contract to be legally valid and enforceable, four key elements must be present: competent parties, legal purpose, offer and acceptance, and consideration. So we need to remember the acronym CLOC. The C is for competent parties, L is for legal purpose, O is for offer and acceptance, and C is for consideration. Without all four, a contract isn't valid. So the first requirement for a valid contract is competent parties. This means that both the applicant and the insurer must have the legal capacity to enter into the agreement. The insurer is considered competent if it's properly licensed and authorized to conduct business in the state. Most adults are considered competent, but there are exceptions. Minors are generally not competent unless it's for necessities like food. Other groups who lack capacity include mentally incompetent individuals, people under the influence of drugs or alcohol at the time of application, persons who are coerced, enemy aliens, and in some states, convicts. Here's an exam tip. An insurance contract only involves two parties, the policy owner and the insurer. The insured and the beneficiary are not parties to the contract. If you see a test question asking who enters into the agreement with the insurer, the correct answer is always the policy owner, since they're the one paying premiums and holding the rights to make changes. The second element of a valid contract is legal purpose. For any agreement to be enforceable, it must serve a lawful objective and not run contrary to public policy. This means that the reason for entering into the agreement and the object of the contract must both be legal. For example, a contract to carry out an organized crime hit is not valid because its purpose is unlawful and not in the public's best interest. In contrast, however, insurance contracts are always considered to have legal purpose because they provide financial protection against risk in a way that serves both individuals as well as society. The third element of a valid contract is offer and acceptance, often called the agreement. An offer is a proposal by one party that, if accepted, creates a contract. In insurance, the applicant usually makes the offer by submitting an application with the initial premium. Without the premium, it isn't a true offer, it's only an invitation. The insurer then reviews the application under its underwriting rules. If the insurer accepts the offer, it issues the policy and the producer delivers it. That delivery represents acceptance and creates the contract. However, the Insurer must makes a counteroffer, such as requiring a higher premium or changing benefits. The original offer is void. The applicant then must accept the counteroffer for the contract to take effect. Importantly, both parties must reach a genuine agreement free from duress or undue influence. The fourth and final element of a valid contract is consideration. This just refers to the exchange of value between both parties that makes the agreement binding. For the applicant, the consideration consists of two things: the premium payments and the truthful statements made on the application. For the insurer, consideration is the promise to pay legitimate claims under the terms of the policy. In other words, as long as the policy owner keeps paying the premiums, the insurer's promise remains in force. This is why consideration is sometimes called as the binding force of the insurance contract. The consideration clause is a policy that sets out the amount of schedule of premium payments. And here's an exam tip. When asked what consideration is in an insurance contract, remember the applicant gives the completed application and premiums, and the insurer gives its promise to pay benefits. Like all agreements, insurance contracts are shaped by the general principles of contract law, but insurance contracts also carry additional features that make them unique. In this section, we'll look closely at what sets them apart, starting with the fact that they are aleatory. Meaning the exchange of value can be unequal. They are also contracts of adhesion drafted entirely by the insurer. Insurance contracts are unilateral because one party makes an enforceable promise, and conditional since the insurer only pays certain conditions if certain conditions are met. Finally, insurance contracts are personal in nature, applying specifically to the individuals named in the policy. These features make insurance policies distinct in the world of contract law, and it's important to understand how each one affects the way policies are created, enforced, and interpreted. So insurance contracts are considered aleatory, which means they involve an unequal exchange of value. One party, usually the policy holder, may receive far more in benefits than what they've paid in premiums, but those benefits are never guaranteed. A covered loss must occur, and the policy must be in force at the time of that loss. Until then, the insurer simply collects the premiums with no obligation to pay. Think of it this way: a person with a disability insurance only collects if they become disabled. Without that event, no benefit is paid. Or consider life insurance. A $20,000 death benefit might be paid after the insurer collects only $100 in premiums. That imbalance illustrates the aleatory nature of insurance contracts. It's similar in concept to gambling contracts where outcomes depend on certain uncertain events. Um, but with insurance, the purpose is protection rather than risk taking. So insurance contracts are contracts of adhesion. That means that they're written entirely by the insurance company, um, and the applicant has no power to negotiate terms. Instead, the applicant must take the contract as written. It's a take it or leave it situation. Because the insurer controls the wording, it also carries the responsibility to make sure the policy is free from ambiguities. If confusing or unclear language exists, courts will interpret it in favor of the insured. This protects policyholders from being disadvantaged from unclear drafting. A key principle here is the doctrine of reasonable expectations. Courts will interpret policies to provide the coverage a reasonable person would expect, even if the fine print might suggest otherwise. This prevents insurers from taking advantage of their drafting power. Finally, remember that insurance carriers can't just create policy forms on their own. They must submit them to the state insurance department for approval before use or modification. So here's an exam tip. If you see a question about ambiguities, remember they're always resolved in favor of the insured. And under reasonable expectations, coverage is interpreted based on what a sensible consumer would expect. So most insurance policies are considered personal contracts. That means that they insure the person, not the property. The agreement is strictly between the insurer and the insured. Because of this, coverage usually can't be transferred. For, for example, if you sell your house, you can't hand your auto or homeowner's insurance over to the new owner. These policies are tied to you as an individual. Life insurance, however, is the exception. Life insurance is not a personal contract. Ownership can be transferred by assignment. The current policy owner simplifies notes the insurer in writing. The company accepts the change, and the new owner steps into full ownership rights. That's why we refer life insurance to buyers as policy owners rather than just policy holders. Insurance policies are conditional contracts. A condition is a requirement that limits the rights in the agreement. For an insurance promise to pay benefits to apply certain conditions must be met. First, a covered event must occur. Um, um, if the premiums stop, the insurer's obligation ends. Another condition is notifying the company of a loss. The insured must also provide proof of loss. Without these steps, the insurer has no obligation to pay. In short, insurance benefits are conditional. The insurer is bound to its promise, but only if the insured fulfills their obligations under the contract. So life and health policies are classified as either valued contracts or indemnity contracts. A valued contract pays a fixed amount that was set when the policy was issued, regardless of actual loss. Life insurance is the most common example. If a $500,000 death benefit was purchased, that's the amount paid when the insured dies. Accidental death and dismemberment policies also fall into this category. Indemnity contracts work differently. They pay an amount equal to the actual loss, designed to restore the insured to their previous financial position. Some are reimbursement policies covering exact medical expenses minus deductibles. Others, like disability insurance, pay a weekly, a set weekly or monthly benefit to replace income. The key distinction: valued contracts pay a preset amount, while indemnity contracts match the benefit to the loss. Another key element of valid insurance contracts is insurable interest, which ties the concept of legal purpose. Insurable interest means the policy owner must have a legitimate financial, emotional, or economic state in the insured's continued life, health, or property. Um, this requirement prevents insurance from becoming a wager if no insurable interest exists. The contract isn't valid. For example, policies like stranger originated life insurance or STOLI are unenforceable because they lack no legal purpose. Insurable interest is assumed in certain relationships. Individuals have unlimited insurable interest in their own lives, as well as between spouses, parents, and children. Business, key employee relationships, and debtor creditor relationships. Here's an important decision. For life and health insurance, insurable interest is required only at the time of application. It doesn't need to exist when a claim is made. For example, if two people buy policies on each other while married, those policies remain valid even if they divorce later. For property and casualty insurance, however, insurable interest must exist both when the policy is issued and when the loss occurred. If you don't own or have a financial stake in the property at the time of loss, no benefit will be paid. In short, insurable interest ensures insurance contracts protect against genuine financial risks rather than serving as a bet on somebody's life or property. So an insurance policy is at its core a written contract. In it, the insurer promises to compensate the insured for losses that result from an unknown event. That's why the terms insurance policy and insurance contract are used interchangeably. The policy is made up of several parts. First, there's the basic policy, which contains the standard terms. Then there are riders or endorsements, which legally amend the policy. Riders can add extra benefits or, in some cases, limit coverage in high risk situations. Finally, the completed application is also considered part of the contract. So if we start talking about the insurance contract, it isn't just the policy form. It's the policy form plus any riders or endorsements, along with the application that was submitted at the start. Insurance contracts are based on utmost good faith. That means both the insurer and the policy owner must be honest and transparent, disclosing all material facts and relevant information. Neither party can conceal, disguise, or deceive. Applicants rely on the insurer's explanation of policy features and on the company's ability to pay claims. At the same time, insurers rely on the application being truthful in their decisions when applying. The principle of utmost good faith underpins related concepts such as warranties, representations, and concealment. Each of these can become grounds for an insurer to deny or rescind coverage if the applicant fails to uphold their side of the contract. Utmost faith breaks down further into three related concepts: warranties, representations, and concealment. A warranty is a statement that's absolutely granted to be true because it becomes part of the contract. If a warranty is later found untrue, the agreement can be revoked. Warranties are rare in life and health insurance, but more common in property and casualty coverage. A representation, on the other hand, is a statement that the applicant believes to be true to the best of their knowledge. Insurers rely on these when evaluating risk. Representation are not a part of the contract itself. However, if an applicant knowingly makes a false material statement, that's considered a material misrepresentation. Concealment is when an applicant fails to disclose a known material fact. If concealment is intentional, it's fraud, but even unintentional concealment can allow the insurer to rescind the policy if the fact if the rescind the policy if the fact was material to the underwriting decision. The insurer must prove both concealment and materiality. Most states limit the time insurers can contest misrepresentation or concealment to a contestability period of 2 to 3 years from issue. After that, the policy is locked in and cannot be voided for those reasons. The terms void and voidable are often confused, but they mean very different things in insurance law. A void contract has no legal effect. It's not a contract at all because it lacks one of the required elements of validity. Since it's never valid, neither party can enforce it. A contract created for an illegal purpose is void. Similarly, if a material misrepresentation is proven on an application, the insurer may void the policy. Avoidable contract, on the other hand, starts out valid but can later be canceled by one of the parties for legally acceptable reasons. It remains enforceable unless the party with the right to void it chooses to do so. For example, if a policyholder stops paying premiums, the insurer has the right to cancel the contract and revoke coverage. So remember the distinction: void means the contract was never valid, while voidable means it was valid but can be undone under certain circumstances. Cancellation is the voluntary act of ending an insurance contract. A policy owner can cancel at any time and for any reason. If the premiums are not paid, the policy will lapse after the grace period expires. The grace period allows payments to be made shortly after the due date without penalty, keeping coverage in force temporarily. Fraud, on the other hand, is intentional deception for financial gain, such as filing a false claim. If fraud occurs, the insurer may rescind the contract. However, life and health insurance policies have contestability limits. In most states, after 2 years for life insurance or 2 to 3 years for guaranteed renewable health insurance, policies cannot be contested or voided based on application errors, misrepresentation, or concealment. Um, Other types of health insurance may not be subject to these same limits. This is why the contestability period is such a key concept. It balances the insurer's right to verify accuracy with the policyholder's right to security after a set time. The parole evidence rule and waiver are two additional legal concepts that affect insurance contracts. The parole evidence rule limits a contract strictly to its written terms. Oral or written statements cannot be used to alter or override the written policy. That means that if a disruption arises, only what's written in the contract will stand in court. For example, if a producer verbally promises certain benefits during the sales process, but they aren't written in the policy terms control. A waiver, on the other hand, occurs when an insurer voluntarily gives up a known right. This can happen through a written statement, a verbal communication, or simply the insurer's actions. Once a right is waived, the insurer cannot later deny a claim based on that provision. Examples include a company officer agreeing to pay a death claim, even though the policy excluded military service, or an insurer that issues a policy despite an incomplete application. They can't later rescind coverage because of it. Waiver can even happen by silence if the insurer discovers misrepresentation but fails to act in a timely way. Together, these concepts show that insurers are bound both by the written word of the policy and by their own actions administering it. Estoppel is a legal principle that prevents an insurer from denying a claim when its own actions or those of its representative have misled a consumer. It basically begins when an agent makes a false or misleading statement about coverage. The consumer relies on that statement when deciding to purchase or adopt coverage. Later, when a claim arises, the insurer points to the actual contract language to deny the benefit. This causes financial harm to the insured. In these cases, the law holds the insurer accountable for the agent's representation, since the agent is acting within the scope of their authority. The insurer is stopped or legally prohibited from denying the claim. For estoppel to apply, 4 elements must be present. An agent makes an inaccurate representation. The consumer relies on it. The insurer refuses to honor it. And the consumer experiences financial harm. If all 4 are met, the insurer must pay the claim as promised by its representative, regardless of what the written contract says. The contract of agency is central to how insurance operates through an agency agreement, also called an appointment. Insurers authorize agents to act on their behalf. An agent's role includes describing company products, soliciting applications, collecting premiums, and providing service to both prospects and policyholders. The agency agreement sets clear boundaries on what an agent can and cannot do. As long as the agent is acting within the authority granted by that contract, their actions are legally considered the actions of the insurer itself. That means under agency law, the insurer is responsible for what its agents do in the course of business. This relationship explains why agent conduct is so heavily regulated and why accuracy and honesty in dealings with clients are so critical. So agency law defines how the relationship between an insurer and its agents works. In legal terms, the insurer is the principal and the agent acts on the principal's behalf when dealing with third parties. This relationship gives authorized agents the power to bind the insurance to contracts, along with the rights and responsibilities those contracts create. 4 principles of agency law follow from this. First, the acts of an agent within their authority are legally the acts of the insured. Second, contracts compiled by the agent are contracts of the insurer. Third, any payment to the agent is legally the same as payment to the insurer. And fourth, the knowledge the agent has regarding business matters is presumed to be knowledge held by the insurer. These principles ensure consumers can trust when they don't deal with an authorized insurance agent. They are, in effect, dealing with the insurance company itself. So another part of agency law is agent authority. Agent authority is the scope of power so yeah, express authority clearly spelled out in the agent's contract. Implied authority covers tasks that are not written but necessary to carry out normal business duties. Apparent authority, which is what the public reasonably assumes an agent can do based on the insurer's actions and relationship with that agent. The most important part is that the law treats and acts of the agent and acts of the insurer as one and the same when the agent acts within their authority. In some cases, even unauthorized acts may bind the insurer if the scope of authority is unclear in the agency contract. Insurance producers can serve as either agents or brokers. While both fall under agency law, their roles differ. Agents represent the insurer and have the authority to bind coverage. Brokers, on the other hand, represent the buyer. They solicit and submit applications, but cannot bind coverage themselves. They must work with an agent or insurer representative who has binding authority. The states also recognize solicitors. An agent can solicit complete applications and bind coverage. A solicitor, however, is limited to finding applicants and introducing them rather to agents. They cannot bind coverage on behalf of a company. Finally, agents also act as fiduciaries. A fiduciary is somebody who holds the position of financial trust and confidence. When agents accept premiums or provide advice that affects a client's financial well-being, they must act with integrity, accountability, and in the best interest of both the client and the insurer. Subrogation is another important legal concept in insurance. It gives the insurer the right to pursue a third party that caused them harm. In order to recover the amount of the claim the insurer already paid to is the insured. Here's how it usually works. If you're in an auto accident, your insurance company pays your claim right away. Then they turn around and seek reimbursement from the other driver's insurance company since that driver caused the loss. Subrogation prevents double recovery, meaning you can't collect from your own insurer and then also collected then also collect from the at-fault party for the same loss. It also ensures that the ultimate financial responsibility falls on the person who actually caused the damage. Contract law governs agreements like insurance policies. Tort law, however, deals with private wrongs that are independent of contracts. By definition, a tort occurs when one person wrongs another by failing to act in a reasonable, prudent way. Unlike crimes, which are offenses against society and handled by criminal courts, torts are addressed in civil courts. The goal is to provide compensation for proven harms, essentially to right a wrong by awarding monetary damages. Negligence is the most common type of tort in insurance. There are three levels. Simple negligence is the failure to act reasonably. Gross negligence involves reckless disregard for safety, showing indifference to potential harm, and willful and wanton negligence goes even further. It's a conscious disregard of care standards, bordering on intentional misconduct. Liability insurance generally does not cover this level of negligence. Just as doctors carry malpractice insurance, insurance professionals need errors in omissions, or E&O coverage. This is a form of professional liability insurance that protects agents from financial responsibility if they make mistakes in their professional careers. E&O pays for both defense costs and damages if a client is harmed because of the agent's negligence. Typical covered situations include failing to place coverage when requested, making administrative or premium errors, misstating policy provisions, forwarding incomplete client information, or failing to recommend appropriate coverage. Even mishandling claims can trigger E&O protection. However, E&O has clear exclusions. It won't cover intentional harm, dishonest behavior, criminal or illegal acts, malicious conduct, or willful violations of law. In other words, it protects against mistakes, not misconduct. E&O is essential because it safeguards both the client and the professional, ensuring that if errors occur, clients can still be made without bankrupting the agent or agency. To wrap up Chapter 3, remember that insurance contracts follow general contract law, but also carry unique features. A contract valid must include competent parties, legal purpose, offer and acceptance, and consideration, often remembered by the acronym CLOC. Um, Insurance companies are aleatory, um, adhesion based, unilateral, personal, and conditional. They may be valued or indemnity contracts, but in all cases, they require insurable interest and utmost good faith. You should also be able to distinguish between warranties, representations, concealment, and fraud, as well as understand void versus voidable contracts, waiver, estoppel, and the parole evidence rule. Agency law is critical. The agent acts for the insurer while with authority that can be express, implied, or apparent. Agents bind insurers while brokers represent clients. Agents also act as fiduciaries, holding a position of trust. Finally, legal contracts include subrogation, tort law, and the importance of errors and omissions coverage for insurance professionals. Together, these rules form the legal foundation for all insurance contracts and relationships. An insurance contract, well, we could maybe do this in a different video. So